The very first question is, should the deposition be taken? And it's a question that seems obvious, and yet lots of times people don't give all that much thought to it. There's a magistrate judge in Philadelphia, Jake Hart, who says doctors take tests, lawyers take depositions. It's the same thing. It's what they do. Hopefully, you will engage in a more thoughtful process in your own practice. There are disadvantages to depositions, and just to tick through the ones that I see, I would say you give the deponent a dry run, and most people get better with practice. And I assure you that every experienced lawyer has seen a witness who was a D, as in David, performer at deposition, and was up to a B or better by the time you got to trial. And you sit there and you think to yourself on the other side of the courtroom, I helped to make him better by taking his deposition. A second is that you preserve harmful testimony. And when you hear that somebody will be reading in the deposition of Mr. A or Ms. B or whoever it is because he or she is no longer available under the rules, ask, well, which side took the deposition that is now going to be read in? The side that will be helped by it or the side that will be hurt by it? Very often what will happen is that you'll find out that it's the side that will be hurt by the testimony that took the deposition. So think about it. Perhaps you want to defer taking that deposition of somebody, particularly if it's somebody who's elderly or infirm or whatever, where you think to yourself, they may move away, their memory may fade. Unless I take the deposition, I may never have to confront that testimony. You force your opponent to learn the case. Lots of times in terms of the litigation process, we're also darn busy that you pick up the file when you have to pick up the file, and you learn it when you have to learn it. And if the other side is going to take depositions and you have to prepare your witness to testify, you learn the case, and then you learn even more about the case when you go to the deposition itself. And finally, depositions are expensive. It's not just the lawyer's time getting ready, the lawyer's time attending the deposition, it's the court reporter, it's travel. Very often today, it's a videographer as well.
The only thing I would add to all of that, Dennis, is that the deposition taker, the questioner, frequently communicates important information to the other side during the process of the deposition. The questions demonstrate what the theories of the case are as they have been formulated by the questioner, and they frequently will reveal facts that are known to the questioner which form the basis for the questioning. And so it is a very common event that at the conclusion of the deposition, the questioner has learned a great deal of information, but has also communicated a great deal of information. And so give thought to whether your deposition that you're thinking about taking will really be more beneficial to the other side in learning your side of the case than you would otherwise want to be.
Yeah. Keep in mind, too, that there are alternatives to depositions. One is written discovery, either interrogatories, or very often you will learn just about everything you need to know by reading the other side's documents, the documents that have been produced in the litigation. And, of course, you can do it the old-fashioned way and just interview the witness without taking a deposition. One small word of caution on that, small but important, is that if you're thinking about interviewing a former employee of your opponent or the opposing party, be sure to check the rules applicable in your jurisdiction And sometimes it can be more than one jurisdiction involved if you're in one state and the witness is in another and so forth, because there are a lot of variations on whether you can or cannot speak to a former employee of the other side, and people who have made a misstep have sometimes found themselves disciplined rather severely by the trial judge.
I would add that the other discovery tools that Dennis has mentioned, such as interrogatories and requests for admissions, particularly when combined with your opponent's documents that have been produced, can be an effective, lower-cost opportunity to confirm much of the information that you need to have confirmed, and give consideration to the possibility of using the less expensive, less risky option of questioning your opponent through interrogatories and requests for admission, particularly relating to documents, than using the documents in a deposition and exposing your theories in an expensive process.
In connection with making the decision, keep in mind that it is possible to cross-examine a witness without a deposition transcript in hand. In fact, the truth of the matter is that the most important cases in America are tried and the witness is cross-examined, and the cross-examiner does not have a deposition transcript in hand, and that is the typical murder case. The witnesses testify, they're cross-examined, and much more may ride on the outcome of that trial than in any civil case. Another consideration, often if you're going to be moving for summary judgment, you want to take the deposition testimony that you want to take deposition testimony because you expect the other side will be using affidavits from these witnesses in opposing your motion. And you want to get what you can to undermine those affidavits. In some instances, you may be better off deciding, let them file the affidavit. I can deal with a 5, 6, 10, 15-page compact affidavit and what the witness says there a lot better than I can deal with what the witness has said over, say, a 2-day deposition, where the judge may look at the transcript and kind of unconsciously think there must be an issue of fact here for trial. All of that said, the disadvantages and the alternatives to taking depositions, there are significant advantages. You learn what testimony you're going to have to meet at trial, so you have much more of a sense of comfort and you're in a much better position to prepare your case for trial. You avoid unexpected surprises at trial by locking the witness into a certain account. The likelihood is the witness will say the same thing at trial as he or she said at the deposition, and if not, then you're in a position to cross-examine quite effectively based on the difference in what was said at the deposition. You can obtain helpful admissions, another advantage of taking a deposition. You ask the witness certain questions, you get an answer, you think to yourself that Q and A is a very helpful admission, a very helpful sound bite, and now I have control of it, I have control of that testimony, I can use it as I want, and you have control because it's already been said. You can also use the deposition to preserve the testimony of a key witness. If a witness is infirm, elderly, etc., and very helpful to your side, by all means take the deposition. In fact, if there's a really essential witness, even if they're young and hardy, etc., it may make sense to take that deposition if the other side does not do so, if they are crucial to your case. And finally, you will usually obtain ammunition that can be used for a motion for summary judgment. For example, in a case where the defendant is relying on the statute of limitations as a defense, and the plaintiff is arguing that the discovery exception applies. That is, that the plaintiff did not discover the facts giving rise to his cause of action until some later period of time, so that the statute is not yet run. Taking the deposition of the plaintiff is absolutely crucial to determining whether you have the stuff for a motion for summary judgment, whether the issue is going to be for trial, or whether, as sometimes happens, you find that the defense is not nearly as strong as you thought it was. Here, as with every subject, the main message is think about it. Think about whether you want to take the depositions or not. And by way of easy example, I tried a case of sometime last year where the other side identified 8 expert witnesses. We decided to take the depositions of 3, though we could have taken all 8. And why we did that doesn't matter for present purposes, except to say that it reflects the fact that somebody thought about it one by one by one and made a decision: we should take this deposition, we're not going to depose that witness. Dave?
I'll add 2 additional goals for depositions. One is credibility. It is very difficult to test and determine credibility of a witness through interrogatories or requests for admissions. One of the primary functions of a deposition is to be able to test whether the witness is a credible witness giving truthful testimony, determine if your party opponent is lying, and to ask questions that are for the purpose of not only learning that the witness is not credible, but proving at trial that the witness should not be believed. That is a very important reason to take depositions, where credibility is going to be at issue. And a final reason to take depositions is to facilitate settlement. We know most cases settle. Depositions can be used to focus the attention of both sides on the merits of their case. And the depositions exchange information. Both sides walk out of the deposition knowing more about their case and their opponent's case than they did before the deposition was taken. So just like the exchange of information through document discovery is important to facilitate settlement, so is the deposition process. Mediations and other settlement discussions are significantly more valuable, more likely to create a settlement when there has been a good deposition taken in advance of that process.